So the Supreme Court just denied review in a case which involved whether the federal law which prohibits nonviolent felons from possessing ammunition is unconstitutional. But real quick before we jump into this video, I want to mention that we are approaching the 4-year anniversary here on YouTube. It's crazy that 4 years have gone by, and I just want to thank everybody for your support and mention that one of my goals is to try and reach 550,000 subscribers by that 4-year anniversary. So if you're not currently subscribed to the channel, if you're a longtime lurker, please consider subscribing to the channel, help me to reach that goal. But regardless, thank you guys all so much for all of your support. So as I mentioned in the intro, in this video, we're going to be discussing how the Supreme Court just denied review in a case which involved whether the federal prohibition on felons possessing ammunition is valid or is invalid under the Commerce Clause. The case we'll be discussing is called Seekins v. the U.S. The plaintiff in this case challenged whether Congress may criminalize intrastate possession of ammunition solely because it crossed state lines at some point and then came into possession of a person who is deemed prohibited from being in possession of ammunition. This case was more of a Commerce Clause challenge, but the Supreme Court just denied review of this challenge. However, the court did not take action in a different case called Rahimi, which may signal that the Supreme Court is maybe going to take a broader challenge to this whole issue of felons in possession of firearms, or maybe even individuals being prohibited from being in possession of firearms because they're subject to domestic violence restraining orders. Now, the facts around this case are pretty absurd. Mr. Seekins was arrested on suspicion of stealing a U-Haul back in 2019, and this took place in Texas. Mr. Seekins was homeless at the time of his arrest, and he survived by essentially digging through trash cans and dumpsters and then taking those items and storing them in the U-Haul. Now, when the police came in contact with Mr. Seekins, they searched this U-Haul. They found a bunch of different items like flashlights, old cell phones, lighters, a spyglass, and then they also found a 12-gauge shotgun shell that was in his possession. Now, originally on review, the police officers didn't believe that this was a shotgun shell. Instead, they actually thought this was a flare launcher shell because they also found in this U-Haul a flare launcher, just a flare gun that Mr. Seekins also found in a trash can. And in that flare gun was also a shotgun shell. But at the time, the police did not believe that this was anything kind of nefarious. They didn't believe that this was any issue. Instead, he was arrested essentially because of that U-Haul. Now, on review, the prosecutors who were bringing charges against Mr. Seekins initially charged him with being a felon in possession of a firearm in violation of 18 U.S.C. Section 922G. However, in the lawsuit, Mr. Seekins and his defense counsel gave notice that they were going to put forward a proposed expert, who would give testimony that this flare launcher that maybe was modified was in no way a firearm and could never meet the federal definition of what a firearm is. Now, in response to that, the prosecutors and the government then abandoned that initial charge of being a felon in possession of a firearm, and instead they changed their position to try and charge him with being a felon in possession of ammunition, also in violation of Section 922G. So originally, the police officers didn't think these were shotgun shells. They didn't think there was any issue with the flare launcher. The original charges were then brought against him, and then they tried to add in the felon in possession of a firearm, became very aware that this flare launcher could not meet the definition of a firearm, so then they changed it. They changed their approach to just trying to charge him with being a felon in possession of these 2 shotgun shells that he found in a dumpster. But ultimately, that ended up being enough, and Mr. Seekins was charged and sentenced with 70 months of incarceration under 18 U.S.C. Section 922G1, for being a prohibited person, a felon in possession of 2 shotgun shells that he scavenged and found in a dumpster. Pursuant to Congressional Commerce Power, Section 922G1 makes it a federal crime for anyone previously convicted of a felony to possess in or affecting commerce any firearm or ammunition, or to receive any firearm or ammunition which has been shipped or transported in interstate or foreign commerce. Mr. Seekins had not purchased these 2 shotgun shells. Again, he simply found them in a dumpster. Despite that fact, the Fifth Circuit held on review that his mere possession of those items was enough to sentence him to 6 years in prison. Now, originally, Mr. Seekins sought a petition for a rehearing en banc in the Fifth Circuit, but it was denied. Now, in response to that denial of the rehearing en banc in the Fifth Circuit, Mr. Seekins then filed a petition up to the Supreme Court seeking a writ of certiorari, and the review that he wanted was whether 922G1 as applied to him is unconstitutional. Recently, the Supreme Court held that under the Commerce Clause, Congress can only regulate conduct that substantially affects interstate commerce or has another evident commercial nexus to interstate commerce. So again, like I mentioned, this was purely a Commerce Clause challenge, really. Here in this case, it appears that Mr. Seekins was trying to springboard off of the 1995 landmark case, which was called US v. Lopez. And this Monday, we got an order from the court on whether or not they would grant review of this case. And ultimately, what we found out in that order listed the Supreme Court is that the Supreme Court denied review in this case. That means that the decision of the lower court will stand for now. However, I will say that although they did not grant review in this one case, Seekins, there was another case called Rahimi, which we did not see appear on the order list of this Monday. Rahimi is a case which is trying to use the Supreme Court's recent New York State Rifle and Pistol Association versus Bruin decision, and it's trying to use that decision to challenge a different aspect of 922G. Ultimately, the Fifth Circuit ruled that under the Bruin decision, their prior precedent was no longer valid, and that the federal law prohibiting firearms and ammunition possession by those with a domestic violence restraining order is a violation of the Second Amendment. Based on the new Supreme Court precedent, the Fifth Circuit found that this section of the federal gun control laws was in fact unconstitutional, and they vacated Mr. Rahimi's conviction of possessing a firearm in violation of that federal law. The government then after that decided to file a petition of writ of certiorari at the Supreme Court, and they're currently seeking Supreme Court review. That case was also distributed the same time that the Seekins case was. It was distributed to conference last week with Seekins, but we didn't see the Rahimi case pop up in this week's order list. That could be because the Supreme Court is going to simply redistribute it. Maybe they didn't address it at that conference, or it could be that they're going to address it here later this week. Traditionally, what happens, especially at the end of the Supreme Court's term, which we are rapidly approaching, pretty much they're not going to hold really any more conferences. That was the last kind of traditional one, was last week. But what they do tend to do is kind of a wrap up where they will address all the current cases that were kind of pending before them. And so this could be that the Rahimi case is going to get wrapped up in that. And at the end of this week, we will find out what actually happened with Rahimi, or it could be simply just redistributed maybe for next term. But one of the interesting things is that if this was just a clear-cut case, maybe they just would have denied it like Seekins. But with Rahimi, there's a little bit of a wrinkle, because if they deny cert in that case, Rahimi, if they deny review, ultimately that means that the Rahimi decision of that 3-judge panel will then sit as precedent in the Fifth Circuit, which of course the government does not want, and maybe even the Supreme Court does not want, and maybe even some of the liberal judges on the Supreme Court also don't want. They don't want a pro 2A decision to be out there, especially sitting in the Fifth Circuit, that maybe then other circuit courts could springboard off of, use as an example to also strike down these types of laws in their own circuit courts. So it could be that Supreme Court maybe is interested in the Rahimi case and simply wants to maybe address that on their own. Maybe we'll find out here at the end of this week, but at least what they did do is they denied review in Seekins, which again, that was unfortunate. We were hoping that they would grant review in Seekins. It was kind of a long shot, just like all these other cases, but the Rahimi case is still out there. We didn't get an order on that, and we should find out here really soon, probably by the end of this week. So these petitions are always an uphill battle. The Supreme Court denies review of more cases than they grant review in. They get thousands and thousands of petitions every single year, and they only take up maybe a couple hundred at best. But that's where these cases currently stand. They denied review of the Seekins case, but the Rahimi case is still pending out there, and there are some indications that maybe the Supreme Court is interested in the Rahimi case because of how the procedure is playing out in that specific case, and just also some of the things that the Rahimi case is addressing. So there was some bad news this week, but we're still hoping that we'll get some good news in regards to the Rahimi case. But if we get any more information, of course, I will let you all know. Also, if you like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.